Hello, my name is Nancy Grimm, and I am the family law attorney for Maryland Volunteer Lawyers Service, otherwise known as MVLS, and I'm here to discuss the differences between third-party custody and de facto parenting. When a non-biological or non-adoptive parent desires to seek custody of a child, that party is referred to as a third party by the courts, and that party may petition the courts for third-party custody. In May 2016, the court granted parental rights to de facto parents. Those individuals may petition the court to establish de facto parenting. The courts presume by law that the parents are the natural and rightful custodians of their children. However, third parties may file for custody if they can prove that the parents are unfit to parent their child or that exceptional circumstances exist that interfere with their ability to take care of their children or child. The court will consider whether a parent is unfit if the parent shows evidence of parental abuse, neglect, abandonment, mental health issues, or other considerations. However, the court must also consider factors to establish exceptional circumstances. These factors include the length of time the parents have been separated from the child and the length of time it has taken for the parents to reclaim the child, the age of the child when the care was assumed by the third party, the relationship between the child and the parent, the nature and strength of the relationship between the child and the third party, and the impact of the custody on the emotional and physical welfare of the child and the child's future, among other considerations. However, the judge in deciding the matter will use these factors to weigh their decision against the ultimate standard of what is in the best interest of the child. In 2016, the court granted parental rights to de facto parents. By definition, a de facto parent is a non-biological or non-adoptive parent. The de facto parent is a non-third-party custodian and is considered a person who has formed a strong and close bond with the child and desires to seek custody and visitation and to maintain their relationship with the child. In this situation, the individual seeking child custody and visitation no longer has to show that the parents are unfit or that exceptional circumstances exist. There is a different set of factors that the individual must show, and they include whether the biological or adoptive parent implied or expressly consented to and fostered the relationship between the de facto parent and the child, that the de facto parent and the child lived in the same household, that the de facto parent provided significant parental functions to support the child's overall development and care, and that a parental-child bond was formed. This new development is significant in that it allows these individuals who have assumed a parental role with the child, such as step-parents and same-sex couples, to continue that relationship with the child, again, all in the child's best interest. I thank you for joining me today, and I hope this presentation has described some of the differences between third-party custody and de facto parenting. If you should have further questions, please feel free to contact me at ngrimm@mvlslaw.org. Again, that is ngrimm@mvlslaw.org. Thank you.